Assalamualaikum guys. Okay, let's continue with the last element of free consent, mistake. If one of both parties to a contract enters into it under some misapprehensions or misunderstanding, in certain circumstances they will be permitted to allege that the contract is defective. Take note everyone, if your contract was affected by mistake, your contract will not become voidable. Okay, your contract can be either void or valid, so it depends on the type of mistake in your contract. If they had known the true facts, they would never have entered into the contract. This is the basic question that arises in the topic of mistake. Okay, if you know that, okay, the true facts of the true facts in the contracts, okay, there is a possibility that you would never enter into the contract. But because of mistake, because of some misunderstanding, then you enter into the contract. This is stated under section 14 subsection E of the Contracts Act. Consent is said to be free when it is not caused by mistake, subject to section 20, 122 and 23. So there are three types of mistake under Malaysian law. Okay, at common law, okay, first we have a common mistake. This is where both parties to the contract make a mistake as to a fact. Okay, please highlight this word. Okay, due to a fact which is underlying assumptions of any fundamental to the agreement. Take note that when both parties make a mistake as to a fact, subject matter of the contract, because subject matter is very important term in the contract. Okay, when the subject matter of the agreement had already perished at the time of contract was entered into and both were unaware. For example, okay, let's say Ali and Abu, okay, enter into contract, okay, where Ali promised to sell his car to Abu. Okay, but the car is not with Ali at that time. His car was in Kedah. Okay, but okay, Ali and Abu, okay, both of them are unaware that the car was destroyed by fire. So at the time they enter into contract, okay, they are unaware of the existence of the car. Both parties tak tahu yang kereta tu dah tak ada. Okay, because it was destroyed by fire. So what happened to their contract? Their contract becomes void. Okay. Next is a mutual mistake where the parties misunderstood each other. Take note, this is not a common mistake, but they misunderstood each other and are cross purposes. Maksudnya kesalahfahaman. Yang ni faham yang lain dan yang seorang lagi pun faham yang lain. For example, A intends to sell his proton wira, but B believes that the offer relates to a proton iswara also owned by A. Okay, so I pointed out that case of reference against Witcher House 1864. Okay, if you have free time, I want you to find this case. Okay, this case is very interesting. Then you may relate it with the type of mistake. Okay, basically in a reference against Witcher House, both parties in this case were negotiating under a mistake, and they had in mind different sheets. Okay, so what happened to their contract? The contract was void for mutual mistake. So still the effect is void. Okay, the third one is unilateral mistake, where only one party make a mistake. Okay, whereas the other party knows or must be taken to know of his mistake. Okay, maksudnya the other party know that this party is mistaken. Dia tahu yang sebenarnya this party dah mistake. For example, A agrees to buy from B a caricature which A believed to be genuine light but in fact was not. If B knows of this fact that the caricature was not drawn by light, then it is a unilateral mistake made by A only because B know, okay, the mistake from A. Okay, so the effect of contract is the contract still valid, not void. Okay, so in our positions, okay, based on our contracts at 1950, first we have section 21, mistake made by both parties. This is also equals to common mistake at common law. So according to this provision, when both parties to an agreement are under a mistake as to a matter of fact essential to the agreement, then the agreement is void. So they stated the effect, okay, of a mistake made by both parties. Okay, matter of fact essential here is referring to subject matter. Okay, so the condition is first must be made by both parties, be of a matter essential to the agreement. So the mistake of subject matter. Okay, so there are a few situations under section 21. First, mistake as to the existence of the subject matter of the contract. You may refer to the illustration before. I give you illustration between Ali and Abu. Okay, the subject matter was destroyed but both parties are unaware of it. Okay, so the contract is void. Mistake as to the identity of the subject matter. Identity, for example, where the subject matter is coming from. Third is mistake as to the quality of the subject matter. Quality. Mistake as to the possibility of performing the contract. Okay, the most important for you to know is the first one. Okay, the existence of the subject matter. Okay, second type of mistake in Malaysia is mistake made by one party only. So at common law, this is known as unilateral mistake. Based on section 23, a contract is not voidable merely because it was caused by one of the parties to it being under a mistake as a matter of fact. So if only one party made a mistake, the contract not voidable, meaning that the contract is valid. Okay, the contract is enforceable. Alright. Okay, the third type of mistake is mistake as to law. Okay, so how this mistake happened? Based on section 22, a contract is not voidable because it was caused by a mistake as to any law enforced in Malaysia, but a mistake as to law not enforced in Malaysia has the same effect as a mistake of fact. Okay, for example, A and B make a contract on the belief that a particular debt is barred by statutory limitations. The contract is not voidable, hence valid. Okay, why their contract still valid? Because they make a mistake as to law that in force in Malaysia. Maksudnya mistake yang dia buat tu berkaitan dengan law yang dikuatkuasakan di Malaysia. Okay, so the contract valid. If they made a mistake, okay, as to law that not enforced in Malaysia, maksudnya dia buat mistake berkaitan dengan law yang tidak dikuatkuasa di Malaysia, so the contract is void. Sebab kat sini dia state the same effect as a mistake of fact. Okay, effect of mistake of fact just now is void. Okay, so please take note. If you not understand this provision, okay, bacalah banyak kali, insyaAllah you faham. Okay, refer to this illustration. And the last type of mistake is mistake of a document. Okay, general rule, a person is bound by the terms of the contract that he signs. However, there is an exception. Okay, when you sign a contract, means that you are bound to that contract. Whether there is an exception? yes, based on this maxim, clear of non as factum, it is not my deed. For example, if the parties sign under mistaken belief of the document due to illiteracy, blindness, sensibility, or fraud. Okay, you may refer to the case of Subramaniam against Ratnam 1965. Okay, in this case is where the defendant signed a written acknowledgement when he was ignorant of the English language. Okay, defendant tak faham pun English, but he signed the contract. Okay, so he is bound since in this case there is no fraud or misread. Okay, so kalau tak pandai baca English, kena minta siapa-siapa tolong translate and then proceed with the signing. Okay, and last but not least is the effects of mistake based on section 14. Okay, contract is void. Okay, so no title can pass under it, neither parties under any obligation to perform. Okay, so this is stated under section 66. Any advantage received under the agreements, then he is bound to restore it or make compensation for it to the person from whom he received it. Okay, this is where the contract is automatically becomes void for mistake. And then let's say if the party have reached an agreement but the document does not accurately record such agreements, then there is a remedy of rectification. Maksudnya you can still make a relevant corrections. Okay, and then you may proceed with the contract. This is stated under specific relief at 1950 section 30. Okay, so that's all for mistake that you must know. Okay, thank you everyone. Assalamualaikum.